In international environmental law, there are a number of principles that form the building blocks or norms of environmental law. Principles such as sustainable development, principles such as the polluter pays principle, the precautionary principle, common but differentiated responsibilities. There are a number of these. These principles have emerged over the last 30 to 50 years. Some are very well established and can be considered customary law or are given legal force through multilateral environmental agreements or other legal instruments. Some are emerging and continue to emerge. Principles such as in dubio pro natura, in case of doubt, decide for nature. Principles such as progression and non-regression. I'd like to take a couple of minutes just to talk about two of the principles in particular. The first, Principle 10 of the Rio Declaration. This was a principle alongside 26 other principles that were decided in the Rio Declaration, which says that environmental issues are best handled when there is public participation, when there is access to information, and when there are rights to remedies, judicial and administrative remedies. It's a principle that we can see on the international scale, not only through the Rio Declaration, but also taken up by UNEP's Governing Council in 2010 through the Bali Guidelines, which further articulated what this principle could mean. We also see Principle 10 given legal force through regional legal instruments. Most recently, the Escazú Agreement in Latin America and the Caribbean. Before that, we have the Aarhus Convention, technically not a regional agreement because it is open to all member states to accede or ratify. But these agreements give legal force to those three core principles of environmental democracy: the right to public participation, the right to information, and the right to remedies. At the national level is where we see this principle really taken up, most principally through environmental impact assessment legislation and also in the decisions of courts. And there are some seminal decisions, including the court in Costa Rica, which gave legal effect to this principle. Another principle that I think is worth mentioning is the idea and principle of non-regression and its corollary, progression. This is the idea that environmental laws should not backtrack or backslide. You should not go backwards in the level of environmental protection. At the international level, the origins of this principle come from international human rights law, and it's relatively new when we talk about non-regression in the field of international environmental law. However, we are seeing it taken up. Most recently, in 2016, at the IUCN World Conference on Environmental Rule of Law, there was a declaration that integrates this principle of non-regression. We also see it in international legal treaties such as UNCLOS, where in Article 136 there is a reference to this idea. On the flip side, progression is the idea that we should move forward in environmental law. Perhaps a really good example of this is the Paris Agreement. Article 4 talks about member states needing to become continually more ambitious in their nationally determined contributions. We also again see it in the IUCN Declaration on Environmental Rule of Law, where there is a specific call for laws to have the principle of progression integrated into them. So, in summary, we have a broad array of principles to varying degrees of legal effect and status, but these principles are fundamental to how we craft international, regional and national legal responses to best manage our environment.